Hi, I'm Michael Carabash, dental lawyer with DMC, and we often get asked, I have these employment agreements from years ago, are they still good? Will they still keep me safe in the event I have to let somebody go? And I will say no. If they're not 2020 and onwards, they're probably not good, because there's been some court cases that have come out which have essentially rendered the termination clauses, all of them, invalid. That first case that came out was called Waxdale, and it changed the landscape for everybody in Ontario who had an employment agreement. It basically said if you have certain wording in your termination clauses, even if you don't rely upon those specific termination clauses to let somebody go, but you just have this wording, not only is that termination clause invalid, all the other ones are invalid too. It's almost as if you don't even have a contract. And if you don't have a contract, guess what? The judge-made law, which we lawyers, we call the common law, that now governs. And I'm going to tell you something. Judge-made law is a lot more in favor of the employee. We're talking, general rule of thumb, 1 month of notice or 1 month of pay for every year someone's worked for you, up to 24 to 30 months. That's a lot. Whereas your employment agreement, if it was valid and up to date and had the right wording, the longest someone could get is like 8 weeks of notice or pay. Didn't matter if they were there for 20 plus years. So you've got 24 to 30 months judge-made law, or you've got 8 weeks under the Employment Standards Act. And that's a huge difference. And that's why you need proper, up-to-date contracts.